Uh, Welcome to everybody. We would like to start by giving the floor first to Hedry and Cummins. Welcome and thank you for opening the event.
Thank you, Emilie. Good morning, everyone. I'm Adrian Cummins. I'm a co-founder and co-director of Lenape Center. It's an indigenous organization based here in Manhattan. I'm an adopted member of the White Turkey Fugate family of the Lenape. And our nonprofit was created in 2009 with the mission of continuing Lenape hawking, the homeland, where we stand today, through the arts, culture, and community. The Lenape diaspora is really spread out throughout the US and Canada and includes 5 federally recognized nations, 3 in the US, 2 in Canada. Our work is a call of returning home to the homeland from a very difficult history of genocide, forced removal, ecocide as well. So I've been asked this morning to share some words of welcome on behalf of the elders of Lenape Center. In Lenape, in the Unami dialect, Nulalendam Muhana Eli Paeku Lenape Haking, Gulau Sihemo and Da Achpiaku. We're glad because all of you have come here to Lenape hawking. Live well while you are here. Live well really is an embodiment of the values, Lenape values of harmony, of reciprocity, of compassion, of balance. A lot that we are trying to bring forth, a lot of values in this time of climate crisis. So with that, we are really honored to be a part of this conversation, to welcome all of you, and we wish you all the best. Wanishi, thank you.
Wanishi.
Good morning, everyone. So it's William here from the Vanuatu mission. We're glad to be your host this morning. And I wish to acknowledge the permanent mission of Costa Rica as a co-sponsor of this event, and also the Normandy Chair for Peace. I wish to thank you for being part of this event. Not forgetting also the major partners that are organizing this event. So I wish to extend this warm welcome to the audience, participants. Thank you for making time to be here with us, to be part of this very important discussion on climate change, and also to those who are watching online. Thank you for your participation. On March this year, UNGA adopted a resolution which requests the ICJ to provide an advisory opinion on the issue of climate change as it affects peoples, especially the rights of people, present and future generation. So today, one of the key objectives of this event is to basically share information, stimulate some interest, and encourage countries and international organizations, and your role as key players in the area of climate change can also add value to the whole effort to support the proceedings at the ICJ. So we look forward to your very interactive discussion to enrich our understanding on processes and as we prepare for the proceedings at the ICJ. I thank you.
Thank you very much, Sanlan William. We now have Professor Dick Robinson to give welcome words from the Normandy Chair for Peace. Professor Robinson is online. Professor Robinson, you have the floor.
Thank you very much, Alyn. And good morning to all of you. Buenos dias a todos. Bonjour a tous. It's a great pleasure on behalf of the Normandy Chair for Peace to also extend welcome and greetings to everyone, those from around the world who are online and those who are in the conference room. The Normandy Chair for Peace and the current holder of the chair, Tony Aposa from the Philippines, Emilie Gaillard, the director of the scientific program, has been a major force for developing cooperation internationally on problems of the environment, on problems of the challenge that climate change is bringing to all of us, and above all, to further the mission of making peace with nature. We cannot have peace on Earth as humans unless we make peace with nature. We are all part of the Earth. We are all part of the biosphere. And this theme has been advanced by the chairholder, Tony Aposa, very strongly from the Philippines in advancing what he has characterized as the Good Stories movement. We have good stories to say about how we shall save the planet. They are stories of restoration. They are stories, as the Lenape have taught us in Lenape Hoking, of reciprocity and being at peace, at balance with nature. And so the challenge of this webinar is to bring these themes together with a focus on the advisory opinion that the United Nations General Assembly has requested the International Court of Justice to deliver, perhaps sometime next year. This is a world unique moment to have all of the nations, all of the international organizations focused on the question of what are the obligations of states today to work on helping all of us in solidarity deal with the problems of climate change, problems that are afflicting us even as we participate in this webinar. It is not just sea level rise and the challenges to the existence of nations and people's homes. It is not just the protection of photosynthesis in the forests when every province in Canada has forest fires that are out of control right now, and the air pollution is moving again toward Manhattan. It's already in different parts of North America from the burning of the fires. We have extreme heat, we have droughts. We don't need to debate anymore what to do. We need to have clear guidance. What are our legal obligations to act, to avert a global catastrophe? And I think we can do it. We have time to reshape our systems, to leave fossil fuels behind and move on to renewable energy, wind and solar, hydropower. Even the waves, of course, create energy that can be tapped around the world. So our mission is to move on beyond what the Industrial Revolution gave us, move into a new kind of ecological framework in which we live as part of nature, with nature, and stop the depredations which, as humans and our economy, we are inflicting upon ourselves and upon the biosphere. I wish everyone in this meeting a great success. The second session, of course, will be on another question that the Normandy Chair for Peace has specialized in. And this is the question of intergenerational equity and how we today shall be good ancestors for those who come after us tomorrow. We have much to do to prepare for dealing with a society that values its young and those who have yet to be born as much as it values itself and those who came before it. So I wish all the participants very good success. And the Normandy Chair for Peace has had a wonderful 3 years of advancing this agenda. It's been my privilege to be the Chair Emeritus of this effort. I want especially to thank and commend in closing Vanuatu. Vanuatu has been a world leader in bringing this question to the International Court of Justice. The mission to the UN has been exemplary in its work with all of the missions to the UN to frame the question and bring the question to the International Court of Justice. And I also chair the International Council of Environmental Law, and we and others, including the International Union for the Conservation of Nature, will be working diligently over the next few months to present materials to the International Court of Justice in support of its advisory opinion. So good luck to you in your deliberations.
Thank you very much, Professor Robinson. Thank you also, Mr. Coleman and Mr. William, for the welcoming words. My name's Alyn Ware, and I'm going to be chairing this session of today's event. And the event is on both the International Court of Justice case, the advisory opinion on climate change, and on the UN Summit of the Future, and in particular highlighting the rights of future generations. And so session one today, we are focusing on the ICJ case itself and on this particular part of the timing of the process, which is encouraging governments and international organizations to participate in the court. And the second session will be looking at the UN Summit of the Future and how the deliberations and where possibly the decision from the International Court of Justice might have some influence on the UN Summit of the Future to ensure that it's an effective summit and that the rights of future generations and the legal obligations to protect the climate for future generations are a highlight and made very strong in the Summit of the Future and in other follow-up processes. So thank you very much for all of those who have joined us today in the room here in New York. Thank you also for everyone who's joining online. And just to let you know that the proceedings today are being translated simultaneously in Arabic, French, and Spanish. Online, you can see that in the translation button on the bottom of your screen. And if you're here in the room and you'd like to listen to it in one of those languages, then if you link into the Zoom link and use your device, your laptop or your tablet or your smartphone with headphones, you'll be able to listen to the translation as well. So
just if you connect in the room, yes, please mute.
Yes, mute
you.
So we don't get the feedback. Thank you, Emilie. A big thank you to the permanent missions of Vanuatu and Costa Rica for co-hosting this event along with Normandy Chair for Peace, and particularly the permanent mission of Vanuatu. As you've heard, Vanuatu has been leading first the core group of countries and then the group of co-sponsors of the UNGA resolution to get this case into the court, and has done a fabulous job of building sufficient support and agreement to this process that the UNGA resolution to take the case to the International Court of Justice got adopted without any opposition. This is really important because it's indicated to the court the support for this approach, that it is really important to be able to have legal clarity on what are the obligations, both to protect the climate for current and future generations, but also to address the impact that climate change is already having, particularly on the most impacted communities and the most impacted countries. Two very important questions going to the court, and the fact that the going to the court without dissension, without opposition, is sending a very strong signal to the court that this is an important case. So much so that we have seen the court already responding favorably to requests not only from states to participate in the proceedings, but from international organizations. Already 3 international organizations have been granted authority to participate in the case. So this is why we invited for this event not only the members of the United Nations, but also representatives of international organizations. Of course, the third constituency is general civil society, who also play a role. And the civil society don't have a direct input into the court, don't have standing in the court, but The different sectors in civil society can play a role to work with the like-minded countries in order to provide information, to provide background stories that can help both in the written hearings of the court and also in the oral hearings, which will come later. And this will be very important for the deliberations and then the final decision of the court. So you're all important, and thank you all for joining. This is an intergenerational event, as we see. There are some of us who have been around for a while and have been involved in previous court cases. I came in as a youngster back in 1990s and was involved in helping to take the case of nuclear weapons into the International Court of Justice. And then we also have some of the younger generation here. Very pleased to see members of the younger generation are being engaged, because it's so important that this does move ahead as an intergenerational event. And we are very happy that this is moving in that direction. So we're going to start with a keynote address from the Attorney General of Vanuatu. And the Attorney General is not able to be with us in person, but has done a pre-recorded video message. And I will now ask our technical person to play the statement from the Attorney General of Vanuatu.
International courts and tribunals are taking center stage on levels to address the existential issue of climate change in a way that prioritizes intergenerational equity and is led by young people themselves. For more than 5 decades, science has been providing stark warnings about the chemical and physical consequences of greenhouse gas emissions. Sadly, the short-sighted and economically-driven policies of many states and the little people's faith. And today, Vanuatu's people suffer from the insidious rise in sea levels that eats away at our villages, ocean acidification that is dissolving our reefs, increasing sea surface temperatures, bleaching our corals and sea grasses, landslides that erase entire villages and plantations, and prolonged droughts that shrivel and kill our subsistence crops before they can be harvested. The political denigration of science was on full display at UN climate negotiations in Germany a few weeks ago, as parties refused to acknowledge that the Intergovernmental Panel on Climate Change ARC's report is the most comprehensive and robust assessment of climate change that we have, and that we must act on its message in warning to 1.5 Celsius for our own and future generations. This result of inaction is harming those not responsible. Climate suffering that is being experienced right now and will be exponentially worse for those born today and tomorrow. Friends, this is not just a Vanuatu problem. One we are experiencing now and have faced for many years, to see the rest of the world beginning to feel. We empathize with you in the United States and the rest of the developed world, and hope that we have the collective courage to get this thing around. 7 years ago, 196 countries adopted the Paris Agreement, the international treaty many hope would finally take us off the path of planetary destruction. Countries around the world celebrated the landmark first step towards what we hope would be accountable, transparent, and life-saving requirements to reduce the impact of global warming. But unfortunately, the pledges, promises, and commitments made under this agreement take us well beyond the safe operating limit of 1.5 degrees. Little effort has been expended on the human rights-related violations linked to climate change. Countries still tend to see the Paris Agreement as the only international law relevant to climate change. International law is broad and comprehensive, and the UNFCCC's Paris Agreement is certainly not only treaty we have, which contains obligations of states to prevent climate harm and protect human rights. That is where Vanuatu's transformative International Court of Justice initiative comes in. With the lack of ambition seen at the UNFCCC. What is actually needed now is clarity from the highest judicial authority on what are those other legal binding climate and environmental obligations and the consequences for states who fail to uphold them. Advisory opinion from the International Court of Justice will draw a clear line between what is an acceptable outcome of UNFCCC climate negotiations and what is a non-negotiable legal responsibility for all states. In our view, climate action is not a mere matter of state discretion. It is an exacting requirement under international law that comes with enforceable consequences. Specifically, we see climate relevant obligations in the Charter of the United Nations, the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights and on Economic, Social and Cultural Rights, the Convention on the Rights of the Child, the United Nations Convention on the Law of the Sea, the Vienna Convention for the Protection of the Ozone Layer, the Montreal Protocol on Substances that deplete the ozone layer, the Convention on Biological Diversity, the United Nations Convention to combat desertification, and more. But how can the obligations under a wide body of existing treaties be applied to climate change? Last week, Alyn University students asked themselves and others this question. They brought ideas to the government of Vanuatu, and we listened. Those discussions grew into a truly international call for clarity and for justice. Vanuatu accepted the call from our youth and has since been leading the campaign side by side with them for an advisory opinion on climate change from the International Court of Justice. The United Nations International Court of Justice is the only principal organ of the United Nations system that has not yet been given an opportunity to help address climate crisis. To get to the court, Vanuatu assembled a core group of 18 countries from Global South and Global North, including Germany and 3 other European nations, to draft a relevant and impactful question to the court. We held multiple consultations and took on feedback in good faith from all corners of the globe. What many told us was wishful thinking became a reality when on 29 March 2023, 132 co-sponsoring nations tabled the resolution at the United Nations General Assembly. Historically, for an ICJ request, our resolution was adopted by unanimous consensus. You can read the full resolution on www.vanuatuicj.com. But in summary, we have asked the court 2 simple questions. First, what are the obligations of states to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases? Second, what are the legal consequences for states where they, by their acts and omissions, have caused significant harm with respect to A, small island developing states and other vulnerable states, and B, peoples and individuals of the present and future generations? It is our view that these questions should have been asked long before now, and that the answer given by the world's highest court will help countries get back on track in upholding the rule of international law and bringing human rights thinking into energy and climate decisions moving forward. I want to be very clear that this initiative is not intended to name or shame any particular nation. And despite being brought to the UN's highest legal body, we are not suing anybody. There will be no winners or losers, and no state will be required to do anything as a result of the advisory opinion of the court. Importantly, we are only asking for clarification of legal obligations already agreed to under international law, and we are not creating new law. The question is also forward-looking, considering both historical emissions, but also emissions of today and the future. The resulting advisory opinion will help states revise and enhance their nationally determined contributions under the Paris Agreement and strengthen domestic laws and policies. The advisory opinion will likely identify gaps in international law, which will help us as we build and improve our multilateral climate negotiation process. The advisory opinion will also ensure we base our relationship on the adherence to the rule of international law. As we have seen with the recent destabilizing war in Ukraine, we must prioritize an international legal framework which is clear on what is acceptable state behavior and what is not. The rule of law is foundational to the United Nations and to its mission of peace. Vanuatu was so proud to partner in this initiative with grassroots, youth movements, and indeed over 2,000 civil society organizations from around the world, as we work to track the forward-looking, indeed intergenerational question now before the ICJ. We will continue to see youth as our closest legal and climate ambition allies in the ICJ process and beyond. So what is next? On 25 April 2023, the Registrar of the International Court of Justice formally published its ratification that A, fixes 20 October 2023 as the time limit within which written statements on the questions may be presented to the court. And the notification also fixes 22 January 2024 as the time limit within which states and organizations having presented written statements may submit written comments on the written statements made by other states or organizations. So right now, states, UN organizations, intergovernmental organizations, and others are invited to prepare submissions with their legal perspectives on the two questions. Sadly, the ICJ will not accept submissions from NGOs, but Vanuatu and many other states are committed to including non-governmental voices in our own submissions, so they are creating ways to ensure maximum inclusivity in the process. What is essential right now is to ensure that first, all states in the global south are empowered to make submissions, and second, that the submissions highlight the substantive obligations found in international law. Let me explain. Many countries in the global south have never engaged in the ICJ and are unfamiliar with its processes. Many do not have legal experience in preparing ICJ submissions and lack access to the evidence and legal drafting experience. We need to lower the barriers to entry for these countries and provide as much pro bono legal and technical support as possible so that the court hears from all states who have contributions to make. I appeal to you all and your networks to contact us with offers of support as we are receiving requests from countries daily. Substantive obligations should be the focus of these submissions. We already know of some states planning to make submissions that there are only procedural obligations related to climate change. We need as many states as possible to highlight specific international instruments and principles which lead to substantive obligations, which in turn trigger state responsibility to act. State submissions have an opportunity to emphasize harm caused based on evidence demonstrating a causal chain up to the whole system through to the source of the emission. Importantly, submissions should strive to answer both questions, the question of obligations as well as the question of the legal consequences, and linking this to the source of international law that the court is asked to look at. As of today, at least 50 global South countries have confirmed they will prepare submissions, but they need help. Vanuatu is convening a rights shop for Pacific Attorney Generals next month, and these have been requested in Asia, Africa, the Caribbean, and Latin America, pending funding. If you have networks or contacts with influence, now is the time to mobilize well before the 20th October submission deadline. Excellencies, ladies and gentlemen, friends, soon the world's highest court report will give us the clarity we all need to do more. We are out of time in Vanuatu, and our children need us to demonstrate the leadership demanded. Here on the ICJ, Vanuatu is taking other actions to strengthen and transform international law for climate action. Vanuatu and a group of the like-minded nation has also submitted a request for guidance from the International Tribunal of the Law of the Sea, ICLOS, on how greenhouse gas emissions are linked to obligations under the law of the sea. We expect that this advisory opinion will be released first and feed constructively into the ICJ justice's consideration. To address the clear gaps in existing international law, Vanuatu is now leading the initiative to criminalize ecocide, which is the unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. Criminalizing ecocide as a fifth crime under the Rome Statute of the International Criminal Court would add environmental damage alongside the most heinous activities known on our planet. Genocide, crimes against humanity, war crimes, and the crime of oppression. With the crime of ecocide able to hold individuals to account, including state leaders or fossil fuel CEOs, we will have clear guardrails of acceptable behavior towards the environment, sending a substantial deterrent. Finally, addressing a major gap in the UNFCCC system is the need to legally motivate phase out of fossil fuels. Vanuatu simply cannot accept the continued expansion of fossil fuel production or an expansion of subsidies propping up this dirty and planet-killing source of energy. Vanuatu was the first nation to call for a fossil fuel non-proliferation treaty, which will complement and indeed strengthen the implementation of Paris Agreement, which has not designed to address the source of greenhouse gas emissions and climate pollution, oil, gas, and coal. Just as addressing the risk of nuclear weapons, landmines, and other threats to humanity required an unprecedented level of international cooperation, so does the Prof of phasing out fossil fuels and accelerating the adoption of clean, low-carbon solution fall to us today. This new international legal mechanism will facilitate the energy transition in a way that is fair, fast, and sufficiently financed. We know this won't happen without a fossil fuel non-proliferation treaty, because without an international agreement, each producing nation will continue to argue they should be the last one to produce the last barrel of oil because they can produce it in a clean way. Momentum for fossil fuel non-proliferation treaty is growing. With Vanuatu and Tuvalu in the lead, there are now 7 nations joining us, 550 parliamentarians, more than 80 cities and some national governments, 101 Nobel laureates, more than 2,000 civil society organizations, the World Health Organizations, more than 1,000 religious groups, and even the Senate of the state of California just passed a resolution endorsing the negotiation of this new treaty. With that, I thank you again for joining Vanuatu, one of the smallest but now loudest voice on transforming international law as a tool to motivate the climate action demanded by and necessary to protect young people. I particularly thank the government of Costa Rica and the Normandy Chair for peace for hosting this discussion with us. We share a belief in accountability, and Vanuatu looks forward to further collaboration with you to shape, implement, and enforce the law. For all here today, know that in Vanuatu, you have a staunch ally committed to utilizing the powerful tools of international law for climate justice and intergenerational equity outcomes. Thank you to us.
I want to thank very much the Attorney General of Vanuatu, for that strong and significant statement and a very good outline of what has been planned, what is happening, and what are the expectations for this advisory opinion in the International Court of Justice. Just before passing the mic to the Deputy Ambassador of Vanuatu, I'd just like to highlight 2 points from what the Attorney General said. The first one is that we need to lower the barrier to the participation of states and international organizations in this case. Even if you are from a country, a UN member state, or an international organization that does not have experience with the International Court of Justice, that should not be a barrier to your participation. You can choose whether you want to make a very substantive and detailed submission or whether you want to make something shorter. And regardless of the length of it, every submission is going to be important. Some states and international organizations may prefer to focus more on the science and the facts, what is happening, the destruction being caused by climate emissions, which is very important. Facts are a very important part of any legal case. Others might want to focus very much on the law and the developing law, and including that protecting rights of future generations. And we'll hear from Professor Gaillard soon about that, the emerging body of law to apply. Others may want to talk about their own experience as a country or as an international organization of how climate change is impacting them. And those stories are also very important. I remember in the International Court of Justice deliberations on the advisory opinion on the legality of the threat or use of nuclear weapons, one of the most powerful submissions was that from the Marshall Islands, which wasn't a long submission, but it was the testimony of Lijang Eknilang, a woman from the Marshall Islands, who talked about the fact that women in the Marshall Islands, because of the nuclear tests that had been conducted 200 miles away from their islands, they had incredible cases of stillbirths, of deformed babies, and she herself had conceived 8 times and not once had been able to give birth to a live baby. Her personal story impacted the judges so much because they could see this is real. It's not just a political issue. This is something which is happening to people. So the stories are going to be very important as well. And with those 3 elements, we encourage any nation state and any international organization to work what's your story, or what's the evidence, or what's the law you want to bring to the court. But of course, there's going to be some collaboration and working to bring these together and find out who's doing what from Vanuatu. So the one other thing I just wanted to mention also in there is it's not just about what the problem is and what the law is, but what might some of the solutions be. And the Attorney General mentioned one of the solutions is to the drafting of a non-proliferation fossil fuel treaty. There will be other solutions that we brought to the court as well. And this is also important, putting out the solutions, because I agree with the Attorney General. We can turn this canoe around. We can do it. And the International Court of Justice is going to play a key role in bringing in the law, the facts, the stories, and solutions will help make that happen. So to tell us a little bit more about what's been coordinated on that and how Vanuatu is coordinating this, I'm going to now ask the Deputy Ambassador of the Vanuatu Mission to come back to the floor and say a little bit more about the process that Vanuatu is doing to help organize this. Deputy Ambassador, Mr. Sanlan Williams, you have the floor.
Thank you so much. Once again, Excellencies, distinguished participants, colleagues, it's my great pleasure and privilege to be here with you today in this roundtable event. I would like to, acknowledge again your very attentive listening and interest in this session. So, building on from what the Attorney General has said with us, I would like to just share with you what we are doing here at the UN to facilitate the process of submission to the ICJ. So climate change is a well-established issue today that may not have been actively considered in conventions developed in the 1980s. The threat it poses to state sovereignty and livelihoods needs to be addressed. Having said that, while we may have treaties and conventions today to address climate change, it has become very clear that we are still doing not enough to stay within the 1.5 degrees Celsius. The IPCC report demonstrates a large gap between indices of states and the actions that is actually needed to successfully avert the climate catastrophe that awaits us. It is because of this and issues of climate justice that Vanuatu, together with a core group of countries, has taken climate change to the International Court of Justice. Today, after a long campaign at the United Nations, together with a core group of countries, Vanuatu successfully passed a resolution in the General Assembly seeking an advisory opinion from the International Court of Justice on the legal obligation of states as it pertains to climate change. At this point, I would like to make a very special mention of our Pacific Youth and Global Youth, from which this whole initiative evolved and is now gaining significant traction. It is because of concern for the future that our youth have boldly initiated and taken this action. The adoption of this ICJ resolution on 29 March by consensus is in many ways a testament to the power of multilateralism and the value of the UN, even in the face of many challenges that we face today. The legal questions contained in the resolution are careful, balanced, achieved after extensive consultation with the UN membership and while safeguarding its integrity. At the heart of the question is a desire to further strengthen our collective efforts to deal with climate change, given climate justice the importance it deserves, and bring the entire international law to bear on this unprecedented challenge. We believe the ICJ can do this. An advisory opinion is not legally binding. However, it does carry enormous legal weight and moral authority. We believe the clarity it will bring can create a benefit our efforts to address the climate crisis and further bolster the global and multilateral cooperation and state contact in addressing climate change. Now that the resolution has been passed, the ICJ, the Secretary General of the UN, we have obviously moved to the next phase. To date, as mentioned by the chair, international organizations such as the IUCN, Commission of Island States on Climate Change and International Law causes, and the EU have received permission from the ICJ to provide submissions to the court. Vanuatu is currently in the process of compiling a template with key elements of the questions to assist other states with their respective submissions. Vanuatu has also compiled a list of pro bono law councils and will share this with states that may need support. From the Office of the Legal Affairs of the UN Secretariat, the dossier of documents is being assembled and expected to be completed by mid-July. Further, we are liaising with the ICJ registrar to distribute information sheets and organize information sharing events for stakeholders in the coming months. Commencing next month in July, Vanuatu, with a number of core group countries, will be hosting 3 workshops here in New York on main themes of the resolution questions. These thematic areas are climate change and human rights, state responsibility and climate change science and establishing causal impacts. So we sincerely hope that the spirit of cooperation and collaboration that we UN member states exhibit through the General Assembly can be translated to the proceedings before the court. Climate change is a critical issue for the entire global community, and especially for our young people who will inherit a world far different from the one we grew up in. We will therefore need all the tools that we have at our disposal to seriously address the most pressing challenge of our time. So we hope, with this in mind, we can count on your support for constructive engagement in providing submissions to the ICJ in the coming months. I thank you.
Thank you very much, Mr. Willing, for outlining more of the cooperation that Vanuatu is organising for submissions to the International Court of Justice, which is very, very important. Now we're going to move to a little bit more on the law that can help feed into this case. And what we're focusing on today is not the full body of law. As you've seen from the Attorney General's introduction, it's a very broad body of law. There's a lot to draw upon. What we're going to be elevating today is law protecting the rights of future generations. And we have an expert on that who did her first thesis as a student on rights of future generations, and then since then has been leading in advancing rights of future generations internationally. And that is Professor Emilie Gaillard from Normandy Chair for Peace and a board member of International Association of Lawyers Against Nuclear Arms. So Professor Gaillard, the floor is yours.
Welcome. Welcome to everybody. Is the sound correct? Do you hear me correctly? Okay. So I'm the scientific director of Normandy Chair for Peace. I'm working aside Tony Oposa, who is the leader, who has planted a seed also of an ICJ advisory opinion in 2016. We played that in the moot court in Hawaii. And the chair emeritus you have already met with, Professor Nick Robinson. I would like to present you, next slide, that in previous cases in front brought to the ICJ, there have been already the very question of rights of future generations that has been raised. And I invite you to have a look on the dissent opinion. So first of all, in 1993, ICJ was very pioneer because they already created a special chamber for environmental issue. But at that time, international environmental law was very new. And as a new law, it was very audacious, creating new principles. The first case where the question of rights of future generations rose was in 1995. Next slide. It's very, very complicated to explain it now, but it has been dismissed. It was about the nuclear test of France, which was going on. And in a dissent opinion, Justice Palmer in 1995 stated that he strictly disagreed with the decision of the ICJ. And he said that new technology has given humankind massive ability to alter the natural environment. And I think it's very important to strengthen that when we talk about rights of future generations, it's very distinguished of rights of youth. I will talk about this later in the second session. When existential threats are at stake, we need a new law with a new frame, a time frame, which is extending to the protection of future generations. And this is really clear in this statement. As you know, also, there is a whole family all around the world. You say that there are pro bono specialists all around the world, and the ICJ can quote and base decision also on academics' work, such as here, there is Professor Brunweiss, which is quoted. So you're already on the next slide. Don't move, Sadvika. So the next slide, I would like to talk about the dissent opinion of Justice Christopher Veramentry, who is like the father of rights of future generations somehow. We have a legacy that he has brought to us. He stated that the case before the court raises as no case ever before, and the court has done the principle of intergenerational equity, an important and rapidly developing principle of contemporary environmental law. We were in 1995. My main message today, and I will repeat it later, is that at that time in the 90s, we were talking about intergenerational equity because we knew that something was going wrong. Now, deeply, I think we are in a new era where we are talking about transgenerational rights. transgenerational rights and duties towards future generations. We are in a new era, a new stage. Next slide. The second ICJ case, which rose the very question of protecting rights of future generations, was in 1994 and 1996 on the advisory opinion on the legacy of the threat or use of nuclear weapons. In that historical case, the ICJ had to answer to the question, is the threat or use of nuclear weapons in any circumstances permitted under international law? Next slide. And the ICJ says that it recognizes that the environment is under daily threat and that the use of nuclear weapons could constitute a catastrophe for the environment. It also recognizes that the environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn. So here we have clearly a common precedent, a milestone for the next ICJ advisory opinion. And it states also that the existence of the general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states. So this is a first milestone I wanted to share with you. Next slide. In that precise case, the answer was no. The answer was that actually, if a state has to self-defense, it can threat or use nuclear weapons. So next slide. Again, there is a huge amount of knowledge and legacy that Justice Christopher Veramentre has shared with us in his dissent opinion. So he said that this court, the ICJ, as the principal judicial organ of the United Nations, empowered to state and apply international law with an authority matched with no other tribunal, must, in its jurisprudence, pay due recognitions to the rights of future generations. So you cannot imagine, when I was writing my thesis in 2008, I had this legacy to share with all the academics, and now we are in a new momentum. This is why this event today and what Vanuatu states and all the states are doing now with this climate case is really historical. I want to share with you the message that we are living a momentum. Next slide. I won't stay long, but there has been also another case in 1997. It was about a concept of ecological state of necessity. I don't have time to share any more on that. The main message would be to say that what do we want to avoid when we talk about rights of future generations? We want to avoid the tragedy of human rights. For those who don't want to green environmental law or human rights, at the end, there will be no more human rights at all, even for present generations. So this is a way I have named this goal, this common goal, to assure a common destiny on this earth. Next slide. So, as I say, the ICJ climate case is a historical momentum. There are three major contexts. First one, we all know that there is a huge and historical wave of climate cases all around the world. And this global context is a major historical signal. The second is that I think that we are living. Next. Yes, no panic. Systemic changes. I will share that in session 2. I will explain to you what is a transformational process in order to transgenerational human rights and to share a new way of highlighting these rights for future generations. And the third context, we talk about internormativity processes. You can go next slide, Sadvika. So quickly, this one is the very first case which opened the wave of climate cases. Next slide. To my point of view, the German Supreme Constitutional Court, which stated for the very first time in history that we have fundamental duties towards future generations, is of major inspiration. And this initiates the processes of metamorphosis of human rights. Human rights are not only for today, human rights are for today, future generations, and no more through an anthropocentric paradigm. This will be my second speech of today. Next slide, next slide. And the momentum, as Attorney General said, there is currently an advisory opinion also that has been asked to the International Tribunal of the Law of the Sea by small island states on climate change and international law. But again, next slide. And I hope that I saw in the registration list that there will be the UN permanent representative of Chile, and Chile and Colombia say that they were looking for an advisory opinion in front of the Inter-American Court of Human Rights. So if you see, there is a momentum. Several jurisdictions have now to answer advisory opinion. I don't think that in the history we have faced the same situation ever. And together we have to work all together, do synergies, and this event is for that. So I brought some hard copies of, next slide, of the book Legal Actions for Future Generation, which is the first book published by Normandy Czech for Peace. And I have to shorten my speech because we want to talk with you all. Thank you very much for your attention. Thank you so much.
Thank you very much, Professor Gaillard, for showing that there is a body of law protecting the rights of future generations, that law itself is expanding, so it's trans-temporal now. It's not just about what is in the moment right now, but what is also stretches into the future. And that's very important, that there are already some precedents in the International Court of Justice that acknowledge and affirm the rights of future generations and the trans-temporal nature of law. And I remember one particular phrase from the nuclear weapons case in '96, which really struck me as showing that the court was taking this approach when it came out with the conclusion that the destructive impact of nuclear weapons cannot be contained in time nor space. That was the conclusion of the court when they looked at the facts of nuclear weapons and their impact over generations. You can say the same thing about carbon emissions. The destructive impact of carbon emissions cannot be contained in time or space. And I think that some of these precedents in the court demonstrate that there is a capacity in the International Court of Justice to really take up this issue, and particularly because the mandate of the court is not just to do treaty interpretation. When it looks at what is the body of law that it can address in deliberating and applying law to specific issues, it's treaties, it's customary law, it's principles of international law, and it's also the teachings of qualified judicians and legal experts. So it can go quite wide, very wide, and probably it's got the widest mandate probably of any court, as well as being the supreme judicial organ of the United Nations. So thank you very much, Emilie, for putting forward some of the law that can be taken to the court. Of course, that's just part of the law. There's a lot more that we saw with regards to what the Attorney General was mentioning in his presentation. Now it's time to hear from a slightly younger voice. And as the Attorney General mentioned, this case was really initiated by youth, first by Pacific Island students fighting climate change, with support of one of their professors, Tony Oposa from the Philippines, and the students picked it up. And we actually have the person who's going to speak was one of the students of Tony Oposa from Normandy Chair for Peace. But as Pacific Island students took this up and then developed a world network of young people, World's Youth for Climate Change, who've really taken this forward and also been doing a lot of the legal work and have developed a legal memorandum and other materials on their website. So the representative we have from World's Youth for Climate Justice is Nicole Ponce, originally from Philippines, and she's online. And I think, Nicole, are you ready to give us a little bit from the World Youth for Climate Justice perspective?
Yes, hello, Alyn. Can you hear me well?
Very well, Nicole.
Okay, thank you. So thank you, everyone. Again, I would just like, in the interest of time, I think we don't have a lot of time, but I'd just like to highlight once again that we stand in the shoulders, brave shoulders who came before us. So I'm so grateful, especially to Alyn for inviting us and always going out of his way to make sure that youth take up space in important conversations such as this one. So I'm gonna try to make it as brief and concise as possible and have time to present the work that we've been doing with the Youth Climate Justice Handbook. So as what the speakers have already said earlier on, there is no general international law instrument which defines the core elements of intergenerational equity, and its legal status is still controversial. So this status quo is quite problematic because there has been evidence and quite overwhelming of the application in international and domestic proceedings. As Alyn has mentioned earlier, it's well known that the ICJ, in its advisory opinion on the legality of threat of the use of nuclear weapons, has referred to the need to protect generations unborn. And in judicial front, there's also a case filed by 16 children against 5 countries before the United Nations Committee on the Rights of the Child, and the case lodged by the Portuguese youth at the European Court of Human Rights against 33 states. And there's also evidence of state practice, which we have witnessed in the case of Minor Oposa versus Factoran and the case of MC Meta versus Kamal Nath. So despite the application and reference by many international and domestic courts of the principle of intergenerational equity, in which a utility of rights is grounded, it has not been expressly recognized as customary international law by international courts and tribunals. But following the historic adoption of the UNGA resolution seeking an advisory opinion on climate change and human rights, the youth and civil society, specifically the Pacific Island student fighting climate change, the World's Youth for Climate Justice, with Columbia University Sabin Center for Climate Change Law, we recently launched what we call the Youth Climate Justice Handbook, which is a tool to assist states in preparing their submissions before the International Court of Justice. And this handbook addresses the obligations of states and the legal consequences under these obligations, and also confronts 3 interrelated crises of the climate, of human rights, and of our planet's ecology. Now, in response to the first question asked, which is, what are the obligations of states under the above mentioned body of international law to ensure the protection of the climate system and other parts of the environment for present and future generations? So in our handbook, it's also, our response is also embodied in our handbook. I'd like to quickly share with everyone. I don't have a copy, but this is our Youth Climate Justice Handbook, the legal memorandum, which you can also access in our website. Our response to the question on the obligations of state relating to the present and future generations is that first, the overarching legal obligation states owe to each other and to present and future generations is ensuring that the climate system and other parts of the environment are protected from anthropogenic greenhouse gas emissions. And second, taking into account the principle of intergenerational equity, this overarching obligation of states requires protecting the environment for both present and future generation. And third, protecting the environment, including the climate, correlates directly with protecting human rights. Very often, environmental degradation leads to human rights violations. Human rights cannot be enjoyed when severe pollution and climate change curtail, among others, access to health and clean water. So this ICJ advisory opinion can be instrumental in recognizing the relevance of the principle of intergenerational equity and climate change, and connect this to state obligations to protect the rights of the current and future generations from the adverse effects of climate change. Consequently, an advisory opinion on climate change and human rights can serve to cement the status of intergenerational equity as customary international law. Now, this is important because intergenerational equity requires that the current generation does not compromise the needs and aspirations of future generations. So this principle has been extensively developed in international instruments related to environmental conservation and climate change, which recognize the importance of preserving natural resources for the benefit of present and future generations. So the Global Youth and Civil Society Alliance considers that the upcoming advisory opinion offers a timely opportunity for the court to clarify the applicability and content of the principle of intergenerational equity. Thus, we urge all participating states and international organizations to support this argument that the status of the principle of intergenerational equity be confirmed as binding international law. So on behalf of the world's youth for climate justice and the global youth, our goal is to encourage states to submit written statements together with an annex containing the statements of those most impacted by climate change, especially during the first round of submissions. So the Youth Climate Justice Handbook can be used as a tool to strengthen states' arguments before the court and for crafting what we call a youth annex. So this youth annex is to be attached to state admissions and contain arguments centered on intergenerational equity, or more broadly, human rights. So to wrap up my presentation, the civil society campaign that first persuaded the Republic of Vanuatu, and through their leadership, governments throughout the world, has since its inception been propelled and energized by students and young people. So the successful adoption of UNJ resolution was achieved through strong partnerships between high ambition governments and organized youth and civil society partners. So Vanuatu's Prime Minister was precisely correct in describing the upcoming ICJ climate advisory proceedings as a young generation's call for justice to the world's highest court. So although only states are permitted to participate in the ICJ proceedings, but all participating states are able to use those proceedings to strengthen and build upon the youth government alliances that succeeded in bringing climate change and soon climate justice to the Peace Palace. So we strongly urge all governments, particularly climate vulnerable states, not merely to participate in the ICJ proceedings, but in doing so, also ensure the voices of their young people are heard clearly and that their testimony is placed before the court. We urge every participating state to involve young changemakers that are actively working to prevent climate injustice in their country in their written and oral submissions to the court, whether this occurs directly or indirectly, in person or through audiovisual technology. It is essential that it be done. So thank you very much, everyone, for your time and attention. I would be happy to take questions later on, and I'll also send our contact information in the chat. Thank you.
Thank you very much, Nicole, for both your presentation and also for the leadership of World's Youth for Climate Justice and Pacific Island students fighting climate change. Incredible leadership and organising from youth. The handbook that you've mentioned there and told is on your website, the World Youth for Climate Justice. It's also on Normandy Chair for Peace website, and we included links in the follow-up to the registration that all of the in-person people have made, and we'll also follow up with the people online. If you don't see it on the chat, we'll follow up. We now come to some time for interventions and questions. I invite Professor Gaillard and Mr. William to come back onto the stage in case there are any questions of them. We will have mics. So this is either intervention, comments, or questions. We will ask first if there are any representatives from UN missions or international organizations. And if it's an intervention, please keep it to 2 minutes or less. And we have a microphone which we can bring around. Oh, there's a microphone at the back also. So Professor Gaillard and Mr. William up here. And if you can let me know if you've got a question or an intervention. I see Jonathan Granoff. Can you introduce yourself before you give your question or intervention?
Sure. I have a couple of titles. in terms of a permanent mission. I'm the permanent observer.
Can you put the microphone a bit closer to you, Jonathan, so that
How's this?
Yeah, that's better.
Great.
Thank you.
Formally, I'm the permanent observer for the International Anti-Corruption Academy, which has an observer status in the General Assembly. I'm also the president of the Global Security Institute and the senior advisor to the Committee on National Security of the International Law Section of the American Bar Association. So I wanted to just pose the counterfactual, which is found in the International Law of Property of the Oxford academics. It's sort of like the Blackstone on the subject. And it sums it up very clearly. The right to destroy is an inherent component of the global right to property. Civil law and common law scholars have traditionally called it the jus abutendi. It's a Roman concept, the right to consume, transform, and abuse. Despite its fundamental nature, the right to destroy is rarely made explicit in domestic or municipal law. And it seems to me that I was once briefed by Senator Ed Markey, who juxtaposed the Civil War in the United States as a battle between absolute property rights, the right to own human beings, the absolute most horrific property right, versus the most minimum human right, the right of people to be citizens. And to some extent, it appears to me that this fight over the future of the global commons is very similar, that this is a struggle of the fundamental human right to have a sustainable environment, which has now been recognized thanks to Costa Rica's leadership in the General Assembly, versus this absolute property right to destroy the commons. And I think that normal people could understand that. That's a very effective framing of the argument, in my opinion.
Thank you, Jonathan. Do either of the panelists want to address this?
I can quickly answer. Okay. So indeed, what you say is from Roman law, and this way of thinking is binary, or subject of law on one side and object of law on the other side. And this is exactly what is bringing us to the tragedy of human rights. And the change of paradigm is here to move on non-anthropocentric way of thinking within human rights. If I want to use a word which is stronger, I would say that we need to enter in a process of decolonization of the notion of property. But we can be in the middle also. We can say that now we don't have the right to destroy the patrimony of future generations. So all the work done by Professor Edith Brandewijs was to propose a earth trusteeship lenses. We are holding this earth as trustee for future generations. And this way of thinking is part of the common ancestral laws of all indigenous people all around this world. And also, she said, Professor Brandewijs, that when she studied all religions, it's also of common sense. So thank you for strengthening on this way, because this absolutely property conception is an infringement for future generations. In my work, I talk about a principle of temporal non-discriminations to say that if we don't take care of the future, not only future generation, because you understood that my way of thinking is transtemporal, transnational, and transspecie. And I say, if you don't take care of the future, you're committing an abuse of powers upon the future. In order to counterbalance this abuse of power, we have to recognize a principle of temporal non-discrimination.
Thank you, Professor Gaillard. Professor Robinson, did you want to make a comment on this also?
Well, thank you very much, Alyn. I think it's very important that we also identify some of the decisions that the United Nations has taken that are based on the stewardship of nature and the stewardship of the planet. The General Assembly adopted the World Charter for Nature, which is an integral set of principles that provide a counter narrative to this idea of property rights, a joint solidarity of responsibility for nature. And so I think the World Charter for Nature needs to be one of the seminal documents that we bring to the court. Another interesting sense of obligation which states have is the duty to conduct environmental impact assessments. Nearly every nation has a national law on environmental impact statements, impact assessments. And the International Court of Justice has already decided in the case of Argentina versus Uruguay, the pulp mills case, that states have an obligation under customary international law to assess the impact of their actions on neighboring states or on the commons. So this is already customary law. The fact that states are not engaged in actively trying to figure out how they are harming the commons, the atmosphere, is a violation of that customary duty, that international law duty. And I think, again, these tools like environmental impact assessment are available for nations to take action, both in the sense of their responsibility and the consequences of that. So we need to mine, if you will, or look carefully at the existing instruments of policy and the principles of law, which are providing a basis for solidarity and common stewardship. Thank you very much, Alyn.
Thank you very much. We do have some questions online, but I'll take one more for intervention or question from the floor before we go to the ones that are online. Do we have another question, a comment or question from the floor? Yes. Can you bring the mic up the front?
Thank you so much. Good morning to you all. My name is Ware and I'm the PR of Tuvalu to the UN. I've got two comments. One is on the aid loss advisory opinion, and the second one is on the FFNPT. But before I make comments on those two issues, let me at the outset say thank you so very much to Vanuatu and Costa Rica for co-hosting this very important event, and the chair of the Normandy piece. I was listening intently to the exchange of to the comments from the opening statement from the Attorney General of Vanuatu, and of course our presenters and the comments that has been made earlier. And to me, this event has been a very enriching event, and I'm trying to think aloud of the impact of the outcome of the advisory opinion from the ICJ, as well as the one from the aid loss. Nonetheless, my comment on the aid loss, Tuvalu being one of the members of the COSIS, the Commission on the of Small Island State on Climate Change and International Law, that initiated the request to the aid loss for an advisory opinion on a similar nature to that of Vanuatu to the ICJ. That one will be coming up soon, and some of the initial submission, I suppose, have been closed, but there has been we have been trying to encourage members to also make submissions to that. So I believe there has been an extension from May and probably to June. I don't know whether it has been closed in June already, or maybe tomorrow, the last day. But I just want to take the opportunity to encourage members, because it is the same legal opinion that we are trying to ascertain from the aid loss. And as rightly alluded to by the Attorney General from Vanuatu, that advisory opinion from the ITLOS will have a lot of impact to the ICJ's consideration of this advisory opinion request from Vanuatu through the General Assembly of the UN. The issue that I would really like to comment on was the fossil fuel non-proliferation treaty. As mentioned by the Attorney General, Tuvalu and Vanuatu is taking the lead role in that initiative. And it is an initiative that if we really look into it, while we are waiting for these legal opinions or the advisory opinion from these two international, the tribunal and the Court of Justice, we don't have to wait for the outcome and then start working on it. I suppose that we should continue the momentum of working on this, but the issue of the FFNPT is something that I guess not many of us really understand the absence of that, because in the Paris Agreement, there is now no mention of whatsoever of fossil fuel. And if we look at the whole climate crisis that everybody are working on, it's all about the fossil fuel, the root cause of the human-induced climate change emission. So it is something that we really have to, as we progress our work on this, to also, I encourage that member countries to start thinking of joining this, the movement to work on a more a solid foundation of getting to the root cause of the climate change or the impact of this emission, and having a non-proliferation treaty on fossil fuel will really help us address this issue. I thank you, moderator.
Thank you very much, the representative Tuvalu. Mr. William, do you want to follow up on either of those points, the ITCLOS procedure and the fossil fuel non-proliferation treaty? Mr. William?
Thank you, Mr. Moderator. I think just piggyback from what the...
Or can you hold the mic just a little bit closer to you so they can hear online? Thank you.
Thank you. Just picking from what the ambassador is sharing with us, I think these two initiatives are very complementary in each other. So we anticipate that an advisory opinion from ITLOS will be delivered before the ICJ one. So we see some very strong connections in both, and they're supporting each other in so many ways. And I think this alliances in supporting, the like-minded countries that are affected by climate change, this coalition that we are building is building momentum, and we see a lot of support, and it's a good step in the right direction. Thank you.
Thank you very much. And maybe I'll just add a little bit more, and just to remind member states and also the international organizations that your first written statement, whether it's to ITLOS or to the ICJ, doesn't have to be exhaustive. It's the start of the process. If you make a written submission, you can then participate in the follow-up comments to submissions that others have made, and you also can follow up even that further with the oral hearings, particularly with the ICJ case. So again, emphasizing the Attorney General's comments that we want to make sure there aren't barriers to participation. We encourage submissions, even if one can't put in a really exhaustive submission in the first round. Yeah. Thank you. Okay, we had, I think, another request for the floor from the back. So can you introduce yourself and then your question or your comment?
Yes, it's just a brief intervention or comment. I'm Jose Hernandez, the legal advisor.
Can you bring your microphone a bit closer?
I'm legal advisor of the Permanent Mission of Chile to the UN, Jose Hernandez, and I wanted to thank the organizers, the permanent missions of Costa Rica and Vanuatu, and also the Normandy Chair for Peace. I just wanted to make a short comment on the because it was mentioned the submission of Chile and Colombia to the Inter-American Court of Human Rights that is ongoing. We believe also that this mutually reinforcing process in these three different tribunals, the Inter-American Court of Human Rights is a different process, but is open also for states, especially for American states, but also for many other states to receive amicus curiae interventions. So it's also an ongoing process. In terms of our participation in the ITLOS advisory opinion, I want to mention that we also made a written statement last week, and we supported the jurisdiction that was requested by the COSIS. So we want to thank very much Vanuatu and all the presentations today that were very helpful, and including the Attorney General. We are going to participate, I'm pretty sure, in the follow-up during the ICJ proceedings. And I want to thank the organization. Thank you. Bye.
Thank you very much. So did anyone want to respond to that? It was just an intervention. Professor Gaillard, you wanted to say something?
Muchas gracias. I think this is exactly what we wanted with this event, to create synergies, to gather all the forces, all the guardians of nature, and to coordinate, because there are so many expertise on those fields. And the initiative through human rights is very important in the Inter-American Court, because it has more a social analysis of human rights, whereas in European Court of Human Rights, more liberal. And in the Inter-American Court of Human Rights, you can also ask for the respecting a soft law. So this is really, really super innovative. And I think this initiative is really going to open also good path for rights of future generations. Thank you so much.
Thank you very much. And I know there was another comment from the floor here.
Thank you. My name is Paul Rahmat from Vivat International, an NGO with ECOSOC status. I want to ask, what's the significance of submission from civil society of individual states, while the IGC don't recognize that submission of that? I need some clarifications and emphasizes of the significance of this efforts from the civil society, youth, or individual states, while the IGC don't recognize that. Thank you.
If I understand your question correctly, it's what are the efforts of civil society and how they'll be included in the submissions. Did I understand that question correctly? Okay, I think I'll go to Nicole first on this one, and then maybe come back to Professor Gaillard and Mr. William. Nicole?
Hello, Alyn. Sorry, I didn't quite catch that.
The question wanted to know a little bit more about how civil society is engaging in the submissions into this case. You mentioned a bit in your presentation, but I think you wanted a little bit more. And maybe it's to help some of the other representatives of civil society know how they can be involved.
Yeah, that's a very timely question. For example, when we had our event in The Hague last 20th of June, we had strategy meetings as well with the ambassador of Bangladesh and also from ambassador from Thailand. And one of the things they raised in a way to help states to help encourage states to file their submissions is to write for everyone, civil society and the youth as well, to write to their Commission on Human Rights and make it an open letter and make it known that this effort, this campaign is happening. So that's one effective way to do that. Start with your Commission on Human Rights and then write to your Department of Justice and make it an open letter, get people to sign on it, and just to encourage your own governments to actually file a submission. And if along the way, the representatives from Vanuatu also mentioned this, to how to lower the barriers to entry. One way of doing that as we have known by now that states also need the technical and legal support, is that Vanuatu is very much available and open to help states in terms of the legal and technical support. So we can definitely reach out to us, WICJ. We have our website, or PISFCC. If you need help in terms of reaching out to your government, whichever country you are, we're a global network at this point. So we'll be able to connect you to the people who are working on the campaign on the ground. So yeah.
Thank you very much, Nicole. And thank you also for, in your initial presentation, reminding of the possibility and the practice for written submissions to include an annex, whereby, you know, a state, for example, that's putting in a statement can put what their perspective is, the law, their position, etc., in there, and then add as an annex a reference to like voices of youth or a statement from youth or something that may not necessarily be their policy, but they can add it as an annex. And we've had that in previous advisory opinions. We had some of the countries put in annexes on, I know we had one from Joseph Rotblat that was attached to the Costa Rica submission. There was another one which was a memo from the International Committee for Red Cross. They didn't have standing, so that was annexed to one of the other submissions. So the annex process is actually, it's got the practice in there for a state to be able to add something, you know, which they want to refer to either from youth or from a scientific perspective as well, that may not be in the body of their submission. So thank you for that reminder, Nicole. I'll just go to Mr. William if there's any more, or to Professor Gaillard on that question, any other aspects for engagement of civil society. Mr. William, did you have any more comments on that? They've already been covered. Okay, I think that brings us pretty much to a close of this session. I want to thank very much our speakers, including Mr. William, Professor Gaillard, Nicole, Professor Robinson, and of course the presentation from the Attorney General. And thank you very much to the Vanuatu team for providing the capacity for the Attorney General to speak. We will be putting these up on the event pages soon. They're not there yet, but if you wanted sort of like to re-look at the Attorney General's speech, for example, we will have that available soon. And all of those who registered online, we will be doing a follow-up to that. We'll be having a short coffee break now, and then we'll come back in 15 minutes. So at 11:35, and then the second session is going to be looking at the linking of the International Court of Justice case on climate and pushing the UN Summit of the Future. Not only that, there are other ways of following up after the court, but particularly to make sure this case is not going to just stand alone as a court case. We want it to influence process, and the UN Summit of the Future is going to be a really important one. So we'll have those connections in the next session. So have a great break. Feel free to talk with each other, and we will see you back here in 15 minutes. Thank you very much.